Welcome, everybody. We are recording this class, and it's a great class to record because we're going to dive into federalism. In the next 35 minutes, we're going to take a walking tour of American history and the Constitution and find out some answers to these big questions. Number one, what is federalism? Number two, where can we find federalism in the Constitution? Number three, why did the founding generation put federalism into the Constitution? How it played out over time, and how it affects us today. So that's a lot of questions, Nick.
I think we lost Kerry for just a second.
Oh.
Yep.
Am I back?
You are back, but you got the question in, I think.
Good, and I was just giving you full credit because you're going to be able to answer these questions for us today and more that come through the chat box or the Q&A. So without further ado, let's get started. Nick, introduce yourself and tell us where it is in the Constitution and why do they have it?
Yeah, so I'm Nicholas Mosvick. I'm one of our senior fellows in constitutional content at the National Constitution Center, and I have both a PhD in American history and a law degree. I always like to say that just so people know, constitutional history, that's my specialty, and federalism is really my specialty, so I'm certainly excited about teaching today. So Kerry, why don't you go ahead, repeat those three questions again, because they're really important so we can frame this discussion we're going to have today.
Yeah, and I think it always starts with, what is federalism? Can you give us a clean working definition of what does federalism mean?
Yeah, and let's keep this as simple as possible. We did this morning, let's do it again. Simply what we mean is the division of power between the federal and state governments. Now, we're going to talk about local governments too, but just start with that really basic proposition. Kerry and I did this earlier today. I think this is great to talk about the balance beam. When we talked about really starting with the Articles of Confederation and thinking how things are balanced. So you think it was going this way, right? The states were way up. The states had a lot of power. The national government had very little power to do things like taxes, economic regulation, treaties, things like that. But we talked about the last 2 weeks when we talked about the Constitutional Convention and ratification, right? So it was misbalanced. We think of the Constitution as trying to rebalance this alignment of powers between the national government and the state government. So that's what we talk about when we talk about federalism. The second question is, Kerry, remind me again, because I know the third one is, why do they put it in there?
Yeah, the second question, and you can use in any order. So why did they put it in there, and where is it in the Constitution? Because I like to find, I like to fact check and I like to find it. So, and I know this one's like ragu, it's like all over, but like, where is it in the Constitution?
Yeah, I mean, I think we ought to take it both ways, right? It is kind of everywhere, and as we're going to talk about throughout the year, federalism is a constant theme because it's part of what we call the structural constitution, meaning that it's part of the very structure of the document itself. We talk about separation of powers. It's the same thing. We can point to particular language and provisions, but it's also kind of throughout the whole thing because it's part of the bigger picture, right? Is this division of power, right? Where does it go? Where does it remain? But we can also find it in particular provisions. Kerry's going to show you some of those to break that down, starting with Article 1. Remember, Article 1 is the legislative branch. The Senate, as we'll talk about originally, we do this when we talk about voting, even talk about amendments, right? The original Senate was elected by state legislators, right? It wasn't directly elected. That required the 17th Amendment to change that to direct popular election. But originally, this was done through state legislators. We can talk a little bit more about why that tells us something about what federalism originally meant. But then there's the powers of Congress, right? Article 1, Section 8, that's maybe one of the easy examples, right? We talk about the Commerce Clause and the Necessary and Proper Clause, taxing power, the militia powers, so the ability of the federal government to call out the state military units for certain purposes. That's a very important way of looking at federalism in the document. In Article 2, we'll talk about this with some cases. I think we will probably get to it today when we talk about federalism issues now. But a great example is, can the president demand certain thing of state governors? Can he order them to do things, right? That's an important question when it comes to what the president can do. Courts, one of the big issues, and we talked about this last week with ratification between anti-federalists and federalists, is how much power did state courts have left? How much power did federal courts have to overrule state laws and the decisions of state judges and state courts? That was a huge federalism issue. And it's not one that ever really went away. It's a pretty important one. We talked about the Fugitive Slave Clause previously. That's certainly important because when we get to the Fugitive Slave Act of 1850, one of the reasons it brings so much rancor is because it forces both state citizens and state officers to help in the recapture of fugitive slaves. And that's a significant change of the balance we just talked about between federal and state governments, right? That's really important. And then the Supremacy Clause. Maybe that's the most important one, because what does the Supremacy Clause ultimately mean? It means that state laws are, if there's a conflict between state and federal laws, the federal law wins, right? The state law loses, right? That's going to be an important theme when we talk about some of these conflicts between the two. But the Supremacy Clause means that, right? That ultimately federal law trumps. And then the 10th Amendment, that's what leaves to states any powers that are not enumerated or given explicitly to the federal government, right? Generally, that's how we look at it, as a reservation of certain powers to state governments, unstated, but a reservation of those powers that they previously had.
So perfect. So it really is all over. You know, it's not in one section. It's defined by, you know, the powers of each branch of government, the powers at each level, who's given the right, and then where do the pieces that are not clearly spelled out left to. So it really is all over. But, and I know you addressed this, Nick, but maybe we take a little bit more of a beat on why did they put it in there in the first place? What was going on? And we'll jump to the Constitutional Convention and say it's September 17th, 1787. They had a long, hot, sweaty summer dealing with this. What are they trying to balance when we look again at what our Constitution does and balances the national with the state level? Why are they so worried? What was going on? And why did they write it in the Constitution all over?
Yeah, and it's a really important question. And I think the theme here is that we have to remember there were constitutions, other constitutions that existed in 1787. Those are the state constitutions, right? And we just talked about the articles, right? The articles didn't really give too much power to the national governments. They left a lot with states, and that was a big reason for the Constitutional Convention. But those state governments still exist. Those state constitutions exist. So, and we talked about last week with ratification, it's state ratification conventions that are doing the action of the people, right? The states, in other words, themselves are choosing whether or not to accept the Constitution. Therefore, part of that background is states don't want to give away too much of the power that they have, right? In other words, there's a balance to accepting that Constitution. And the framers know this, right? They need to write a Constitution that gives more power than the articles for a variety of reasons, right? And we've gone through those, whether it's declaring war or treaty making or economic regulation. They need more power, but they know that if it takes too much power away from the states, then it's not going to be accepted, right? There are people who certainly would have given more power to the national government than the states, like Alexander Hamilton, but for the most part, right, the consensus is, look, we've got to balance this because we need this to be acceptable to enough states and the people ultimately themselves who think of the states as the first government they know, right? Local and state governments is kind of where, if you put yourself into that 18th century citizen's mind, the duties that they have, Republican citizenship that we often talk about, they start with state local governments, right? Talk about militia duty and jury duty, and the obligations that state governments also have to their own citizens. So from the standpoint of the people themselves too, they often see state and then local governments is the most democratic vehicle available to them. And so therefore, keeping enough power in those governments that existed is also really important to the balancing that the Constitution has to do.
Awesome. Now, real quickly, we talk about the structural constitution, and it's, we have this ability to look at federalism in a vertical sense. I always mess up my vertical and horizontal, but I think I got it right that time.
Yeah.
In a vertical sense. So we have the national government, state government, and local government. But we also look at then that national government and see how power is spread out. Typically, we talk about this about separation of powers or checks and balances, but we have to understand that and its base level to understand how does the system work overall? Whose job is it in a vertical sense and in a horizontal sense? So real quick, walk us through that national government. So we'll dive into this section right here at the national level, and then we'll dive into the states and kind of whose job is it in the national government to have that power for that particular spot.
Yeah, so one thing I think is important there, and we've talked about this, but I think it's worth bringing it out, which is duties are also important too, right? One thing we want to do when we talk about the Constitution, talk about federalism specifically, is to understand that it's not just about limitations or division of power. It's also about duties, right? Affirmative duties in that sense too. Who has an obligation to citizens? Who has a duty to do certain things, right? And the allocation of those is also part of the federalism structure, right? So that's actually an important background too. How it's split, as Kerry suggested, right? This is kind of where separation of powers and federalism, it gets a little messy, right? There's a convergence, so to speak, right? Or kind of a mix. Madison kind of put it that way himself in Federalist 39 when asking or answering the question of, so is this a national government or is this a confederation? And he says neither, right? It's neither wholly national nor a wholly federal, right? It's a mix. I think that's an important concept, not just to federalism, but kind of to the Constitution generally. It's a mix of things. We talk about separation of power. It's also not strict separation of power. Things are mixed. And as Kerry suggested with that understanding of this vertical, vertical and horizontal structures, it's messy, right? So we talk about making laws. Maybe the most clear point in which we deal with the problem of federalism, right, is we discussed earlier, this talks about things like the Commerce Clause, right? The ability of Congress to make laws that deal with economic activity between states and between citizens, right? And that in and of itself is something the Supreme Court has to deal with. We'll talk about what that actually means in practice, but they have to think about that, right? I think, Kerry, how I'm understanding is it's sort of a question of they have to take that constitutional duty and what the Constitution says and then actually do it, right? And so therefore, every branch has to think about the Constitution. So Congress has to think, okay, is this something we can do? Is it actually comport with federalism, right? Are we doing something that's national, in other words? The president, when he deals with emergencies or disasters or calling out the National Guard, for instance, something both of which have come up lately, he has to think about federalism and what duties a state governor has, what state governments have as duties, and whether or not he can do certain things to either force them to comply or to help them, right? It depends, in other words.
Yeah, and I think, and Nick, I think that's, and I'm going to go to Nick's question in the chat because it's a perfect question for the, I think it's really important when we see something happening in like on the elections or in education or in natural disasters, which Nick knows is my favorite to talk about. You have to start with, wait a minute, whose job is it?
Yep.
Because at times, people send a call on like, say the president or say the governor or say the mayor, and it's not their job to do that part. Federalism separates the jobs as well. Not, again, vertically and horizontal. And there's you have to really understand whose job it is and in which kind of bucket of these maps that it really falls into. So here's Nick's question, kind of bringing us back to that moment in time. So, the founding fathers and Madison, they write this idea of federalism where there's overlap and there's interconnecting points. Nick's question is, does Madison change his views on federalism? didn't he want the national government to strike down laws, then later wrote that the states did not have to follow them, like the Alien Sedition Acts?
Yeah. So it's a great question, and for one, I'll be explicit that kind of goes into this later, what's called the idea of nullification. And to be clear, there are two objections to the Alien Sedition laws written by two states. So Kentucky and Virginia passed resolutions. One is written by Madison, the other by Jefferson. So Jefferson writes the Kentucky one, Madison writes the Virginia one. Madison is less, he's more circumspect. He's limited in what he wants to do. Jefferson actually initially writes language that's more explicit about saying states can strike down laws as unconstitutional. They can willingly do so. Madison says, we should probably pull back a little bit on that language. The earlier part, though, actually, this is where there's kind of, you can find, if you look in the Federalist papers, a little bit of existing tension between the views of Hamilton and Madison. So it's Hamilton, who I think is more explicitly nationalistic in his view, who more embraces judicial review. When you look at Federalist 78, we'll talk about that more in Article 3. Madison doesn't write that. Judicial review was an idea in existence for sure, but this is actually gets to very much the tension between the view of Federalists who become a party and then the Jeffersonian Republicans who also become a party in the 1790s. The Federalists are the ones who tend more towards not just judicial review, but what we call judicial supremacy. And the Republicans are the ones who come up with something called compartmentalism. The idea is that both states and the federal government and every branch, they all have a duty to review actions and make sure that they comport with the Constitution. In other words, it's not just the job of the Supreme Court or judges to decide whether or not an action is unconstitutional. It's everybody's duty who swears an oath to the Constitution to do so. So that actually just kind of gets to a very important early discussion. So to the extent that which Madison changes his mind, scholars disagree with that generally about how Madison does change his view of the Constitution over time. But I would just point out that it's actually Hamilton who has more explicitly the views about judicial review in the Federalist Papers. And Hamilton doesn't change his mind.
Yeah, he thinks
well, not on
right.
that.
Not on that.
You can see the play for the times he changed his mind.
I love the idea and that theory that everybody has a job to check the Constitution, and that includes we the people too. So okay, so yes, I'm really liking that one. Yeah, I super love that. Now let's make sure we cover our bases.
I was going to say, Hamilton should take us right to McCulloch, right? Yes, because who writes the National Bank Act, right?
Yeah, so let's talk about it. Give us the background of the story. Not all the students know this. A lot of you probably do, but let's make sure we go through this major canonical landmark case. Go, Nick.
Yes, and I just said Hamilton. I just mentioned the play. My understanding is there's a song about this. Please don't ask me. I'm not an expert on the play. My wife and my in-laws are. I am not. In any case, I think there's a whole discussion of this, but it is one of the first great constitutional debates of this nation. This is something worth always keeping in mind, right? We ratify a constitution, we write it, but then there's this whole slew of questions in 1789 about what does this new constitution do for us? What is it? What are our duties? What does the new government look like? How do we interpret this thing? There are so many questions that have to be answered. And Hamilton is the first Secretary of Treasury, and he comes up with this economic plan. And it's a 5-part plan. We don't have to get into it, although read the report on manufacturers. People will rightfully tell you it's one of the most brilliant pieces of writing we have early on. And Hamilton talks about state debts. We talk about that, how we deal with them, but he also wants to set up a national bank. Hamilton wants to do this because he thinks dealing with debt and having a national bank is what nations do. He says that's what European nations do. That's what Britain does. We should do the same thing. It will make us stronger to have this. States can't deal with these national issues of economics and finance, right? In other words, a nation needs to be able to hold on and create debt, and therefore they need to have a national bank to do so. Madison and Hamilton have a huge debate in 1791 over this. Jefferson also weighs in on this. Madison and Jefferson think it's unconstitutional, but eventually it gets passed. It's a hard debate, it gets passed, but it's chartered for a limited period of time. who is it who signs the Second National Bank Act? It actually comes up at the end of Madison's second term, just before Monroe gets on. There's a second national bank that's chartered, right? And it's controversial the second time around too. And the state of Maryland decides, in order to deal with this problem, we're going to take action as a state. We just talked about the Kentucky and Virginia resolutions. Well, I think Maryland's thinking the same way too. We as a state have powers still, right? We can do something. So they decide to tax the national bank, right? They decide to do so in order to force it and to limit its incursion into what states can do to deal with the finances and economic regulation of its own people, right? So this reaches the Supreme Court. Before we got started, we mentioned some of those who involved in the argument. That included Luther Martin, the great founding father and orator who was an anti-federalist, who actually left the convention because he disagreed with the Constitution. And he argues for the state of Maryland all these years later, right? Think about that, 30 years later. And now he's there for the state of Maryland saying, look, the state can do this. They can pass a tax to interfere with a national bank. And the other thing is there's real life events going on here. The Panic of 1819 in the eyes of many historians is kind of the first real economic depression after the Constitution is passed. And it's a big deal, right? It's formulative in terms of how people view the federal and state governments, the kind of worries that they have at this point, right? So this is a really important point in time. Supreme Court is finally going to weigh in on this question that's been around for nearly 3 decades. What do? Well, it's Chief Justice John Marshall who answers the question. John Marshall, of course, was a Federalist himself. He was at the Constitutional Convention, the ratifying convention for Virginia, who argued in favor of judicial review, amongst other things. And now he says, yes, the federal government can do this. In other words, Hamilton was right, Madison was wrong, right? So the bank opponents had argued that a national bank went beyond the enumerated powers of Congress under Article 1, right? There was no explicit power, in other words, to charter a bank. That's what Madison said. Marshall says, no. He says, look, the problem here is one of federalism. I'm going to go and quote what I think is a great quote out of McCulloch. Marshall says, to the formation of a league such as was the Confederation, meaning the Articles of Confederation, the state sovereignties were certainly competent, meaning state powers, right? But when, in order to form a more perfect union, quoting the preamble, it was deemed necessary to change this alliance into an effective government, possessing great and sovereign powers and acting directly on the people, the necessity of referring it to the people and of deriving its power from them, that's popular sovereignty, was felt and acknowledged by all. The government of the Union, then, is emphatically and truly a government of the people, in form and in the substance and eminence from them. Its powers are granted by them and are to be exercised directly on them and for their benefit, right? So he brings in that popular sovereignty. And then he goes to supremacy. He says, look, the national government was one of limited enumerated powers, but it was also supreme in its laws, right? And that means supremacy over state laws. And then he talks about what we would call implied powers now. And he says, look, there are implied powers because there have to be, right? In other words, Marshall is saying in order to carry out these enumerated powers, Congress must have some sort of implied powers in order to do so, right? It couldn't possibly be limited. Otherwise, it would go against that earlier statement he said about creating this new government through popular sovereignty that had greater powers than the Articles of Confederation, right? That's how Marshall is thinking. And so he turns to the necessary and proper clause. And he says, the necessary and proper clause tells us where these implied powers come from. And the court then concluded that Maryland had no right to tax national institutions because the power to tax involves a power to destroy. The state governments couldn't possibly have done this. We know this through the Supremacy Clause, and we know this because of the reason why the national government was created in the first place. So that's McCulloch. Hopefully that's a good summary, but we need to know this case.
It's a great summary. I literally want like every student to like make a chart right now and say like, here's the preamble, this is what he cites. Here's the idea, here's popular sovereignty, because he really does lay it down and pull, here it is, and this is how I'm defining it, and this is how it lays out. And I love that he starts with the idea that the people give this right, power, and energy when forming a union. Therefore, the national government has to be able to act. So once given power, it has to be able to act and do for the good of all. So it's a great case to know. That's why every high school kid usually has to know it, but it's always a good one to always know. Now we have 10 minutes left. So I'm going to do go ahead, Nick, do you want to add something?
I was going to say, it actually, to me, we can transition quickly to Civil War because I think it actually makes sense. Because you know who thought a lot like John Marshall when it came to federalism? That's Abraham Lincoln.
Perfect.
So the Republicans, right?
Time warp about,
yes,
almost 100 years later. And let's look at the Reconstruction Amendments, which Lincoln did not write the Reconstruction Amendments, but the idea that we, the people, created this union, therefore the union cannot be dissolved, is all looping around. Precisely. It has power. People gave it power. Now it has to do good for people. So Reconstruction Amendments, you've got 2 minutes to break it down, Nick. What do they do and how do they change or shift the power of federalism in some ways?
And let's just take it from Kerry right there too. There's just a statement about the Civil War and the era itself that's really important here. Is it's fundamentally, these issues are about federalism. Slavery was ultimately a federalism issue because state law created slavery. But what ended it ultimately, right? Two things, right? Well, we might even say three, right? Congress acted and an order in some ways, but of course, Lincoln, the Emancipation Proclamation, it's an order of the president. It's an executive order, right? And a military order. And that was, of course, the border states were the loudest protests. The ones who were still in the Union, who still had slavery. So that was Maryland, Delaware, Kentucky, and Missouri. They were not happy about this, right? So he overrode, it seemed to them, state laws in that sense. And then the 13th Amendment, which is a national amendment that says, amongst other things, we see neither slavery nor involuntary servitude, except for is a punishment for crime, shall exist within the United States or any place subject to their jurisdiction, right? It's really important. And Kerry pointed this out earlier today. The enforcement clauses of the 13th, 14th, and 15th Amendments are all very important because it means Congress has power to enforce it. That's a duty, right? In other words, it creates a duty of the federal government to enforce these amendments. And I talked about this earlier today. I think it's just worth noting. The Republicans who wrote these amendments, they took that enforcement power from an 1842 Supreme Court case called Prigg versus Pennsylvania, which actually had been a relatively pro-slavery decision because it had overturned a Pennsylvania personal liberty law, which took away from state officials an obligation to aid in the capture of fugitive slaves. The Supreme Court struck that down, and then they said that the Fugitive Slave Clause gave an obligation to the federal government to create a remedy. Well, the Republicans said, we're going to take this machinery of slavery and use it against it to destroy it and to create civil rights for all. And so they said, yes, we should have obligations to carry out, but that obligation now is to protect these rights, right, and to enforce them. That's a really important change, I think, and that actually gets at the heart of what these amendments are doing. And the 14th Amendment, we've gone over this before, but it's worth always repeating, right? There's a lot in there, right? There's the Citizenship Clause, which creates birthright citizenship. That comes from the 1866 Civil Rights Act, which was passed on the basis of the 13th Amendment. And then it creates three separate rights clauses, right? The Due Process Clause, the Equal Protection Clause, and the Privileges or Immunities Clause. All ways in which the federal government could limit the actions of states and could remedy state violations or down the road, theoretically, private violations, according to some, against civil rights, right? And that's really important. And the 15th Amendment, just to say shortly, right, because we'll talk about voting rights more in another class. But voting was always traditionally something states controlled, and it's still mostly true. But this was also a limitation on what states could do. And it's important to see it through that federalism lens, right? To see that these are all ways in which states were limited in what they used to be able to do. And I think that it's important to see how that shows how the Civil War period really changed how people understood federalism.
Awesome. Nice job. Really quickly ran through that. And you guys can see I highlighted.
Yeah, I need a drink.
Yeah, I know. More power, more power, more power to Congress. And then we can really quickly talk about.
In duties, remember.
Yeah,
power
I
and
love
duties.
the way you said that. I wrote it in the chat. Is like the idea of thinking of federalism, like what is the branch's duty? What is the level of government or that person in government's role and duty? And thinking of the states, I know we talked about this in the last class, but thinking of the states having the duty to be most reactive to the people. So the policing powers, the local government and a state government, don't think police, think policing powers. But they're the closest to the people, therefore they should be the area that their duty is to be directly responsible for the people, and the national, by looking at the national needs of all the people, we the people. So a great way to break it down. I know we're going to jump into a modern question right now, but I just want to like literally glance at the Slaughterhouse case and tell you it's my least favorite case to go over because it's so confusing. But one sentence, what can you tell them about the outcome of the Slaughterhouse case? And yes, it was a slaughterhouse.
It's confusing if you go over the facts, which we will not. So instead, we will summarize it as quickly as possible. And that's just to say that the Supreme Court took a case about the meaning of the 14th Amendment. And I mentioned those three really important clauses. Well, they basically eliminated the privileges or immunities clause. They heavily limited what it could do to protect violations of rights at the state level. And that had the long-term effect of forcing people to use the due process and then later the equal protection clauses as a way to remedy violations of rights.
Good. That's a great way to summarize it. And when you
that
look
was one
back
sentence.
and we have an interactive, that was one long sentence.
Yes.
We have an interactive we have an interactive online called the drafting table on the Interactive Constitution that will really help you kind of break it down. And we are going to dig into this more in November when we do slavery in the Constitution and the 14th Amendment. So don't worry, we're only going over it lightly.
We'll talk about Slaughterhouse again, don't worry.
So we have a real quick, like 5-minute wrap up, but Nick, to keep you on your toes, I'm going to give you a different federalism question. And so here's the big question for everybody. And guys, feel free to answer this in the chat first. So when we think about federalism in play and you want to talk to each other about it, talk to your students if you're a teacher about it, talk to your family about it, you can look at the response to COVID and how can we see federalism? Whose job is it? Whose duty is it? And here's the big constitutional question. Can a state impose temporary limits on the number of people that may gather in order to stop the spread of a contagious virus, even if that means shutting down religious gatherings over 100 people? There's so many Easter eggs in this question, it's not even funny. And what I like you guys to do, you can kind of answer this, and Toby already is jumping in, that is awesome. I love big questions too, Nick. There are certain words that I want you to pay attention to because right now, Nick and I are in the state of Pennsylvania, and this is a case that is going through the courts now. And the question around that case was impose temporary limits. That was the question that the court was looking at. Were they temporary? Were they not temporary? And was it done in an equal and fair manner? So I'll give you guys a minute to kind of answer. During normal times, absolutely not. Toby chimed in. Nick likes the big question. Nick, break it down for us. What are kind of and I know how you're gonna answer this. Mary says no, good answer. You're gonna say, well, it all depends, because that's what it is.
Yeah, well, I mean, I think the history here is important if we just, go over it briefly. One, Kerry already mentioned police powers, and police, of course, that has a very ancient meaning. So policing, really, we're talking about regulation of the people, of the public health and safety and morals of the people. That's what we're talking about, which was always thought to be an original power of the states. Even some theorize it really came from the king and from earlier sovereignty. In other words, that states had ultimate power over these particular regulations. And a 1905 Supreme Court case dealt with an outbreak of smallpox in Massachusetts, in which mandatory vaccination was part of what the state did in order to act against it. And the Supreme Court upheld that regulation and said it wasn't a violation of the 14th Amendment. It wasn't a violation of liberty or religious liberty, because the people who sued were a member of a religious sect, and it said that it interfered with their religious freedom. The Supreme Court struck that down. What's important about that is, one, they say that states have a lot of latitude to issue these regulations, but they also say that it is possible that regulations could be so arbitrary that they could actually infringe upon fundamental constitutional rights, right? So that kind of sets up what we're really talking about today. And the Supreme Court actually dealt with a case out of California. I believe it's called First Pentecostal Church. And that's kind of the breakdown of the argument between the justices, that Chief Justice Roberts said, look, the facts could change. It could appear in a couple of months. This isn't temporary. This isn't limited, but we'll see, right? Right now, it looks like something states can do, even if it means treating religious services and churches different from, say, gyms or something like that, right? And the center said, no, unless there's a good reason given for treating church services differently, they should all fall under the same set of regulations. As Kerry mentioned, the Pennsylvania case is a little bit different because that deals with businesses generally and indoor dining and indoor services, the length of time for the regulations and how businesses are treated differently. But Pennsylvania court actually struck down the governor's order. So we do see that as a possibility here, depending on the particular facts. And I think that's actually what's really important too.
Nick has a great question here, and again, reminds me of Pennsylvania, because we're having so much fun with testing out federalism in Pennsylvania. In theory, could a governor overrule a mayor's mask mandate? I know, I mean, we know what happens in Pennsylvania. The governor said, you know, this is the ruling, and the mayor kind of upped it and made it, in mayor of Philadelphia, let me clarify that, and made it more restrictive. Question, Nick, for you, could he go lower? Could he say like, no, you don't have to wear one in Philadelphia?
Yeah, I mean, it's an interesting question because it's a reminder that in a lot of fields of regulation and rights, states and localities sometimes are able to actually be more restrictive as long as there's a baseline, in other words, and then there's a question of whether or not they can be more restrictive. This question seems to come out of Georgia, where I think there was the biggest issue of whether or not a state could overrule, say, the city of Atlanta's regulations. The thing there is this reminder that state constitutions matter too. And state constitution and state laws often tell us a lot of what governors have in terms of particular powers, restrictions on those powers, what they're able to do, whether or not they're able to overrule local ordinances or not. It's reminded that police powers typically start with the state governments, so they usually make the supreme guidelines within the states. But overruling it is often, that's a matter of state constitutions, as far as I know. So it is actually a reminder too that in federalism, when we go back to that earlier chart, it's not only national and federal governments, but we also remember that there's a division at the state level between the overall state government and the localities. And that fight can come down to state constitutions, although of course there could be federal government or federal constitutional violations as well. So that feels a little bit like a non-answer, but it's just to say that this is also why state constitutions themselves matter. And it's less obvious than it appears because it sort of depends on the state itself, because different states give different amounts of powers to their governors as well when it comes to something like even issuing emergency orders.
So it's always that's what's the fun part about federalism, is it's not as hard as it seems, and it makes total sense. The tricky part about federalism is answering, can they do that, and whose job is it? So that's where you have to dig down into like your local, your state, and your national and kind of leveling it out. But it really keeps us on our toes, but makes us very different than any other country. I have found, and we see a lot of people in government from all over the world come to the National Constitution Center. And I have found this is the one that kind of blows their mind the most. They're like, wait, what? And they like have a hard time wrapping around it because it's very different than many other countries. Okay, so on this note, we are going to wrap up. There was a question earlier from Toby that I am going to have Nick answer.
Sure.
But before I do that, I wanted to say officially, thank you guys very much. It was great to have you in class today. We are doing this class again on Wednesday, and Friday will be the all-in fun session. So we'll see you next time in class, and I will officially stop the recording.
All right.
And I will get you that question, Nick. Hold on.